Well, hello, and thank you all for joining us. My name is Linnell Hartway, and I am a program manager at the National Council of Juvenile and Family Court Judges. And today's webinar is focusing on a resource that we developed in partnership with OCSE and with the funding assistance from FYSB. And we're going to go over that resource today, which is Child Support When You're Afraid of the Other Parent. And if I'd like my other presenters today to introduce themselves.
Hi, this is Gina Tharp, and I am a programs manager with the Department of Human Services Child Support Agency in Oklahoma.
Hi, this is Nancy Copter. Excuse me for coughing at you. I am a policy attorney and domestic violence goddess at the Division of Child Support in Washington State. I work in headquarters.
This is Michael Hayes with the Federal Office of Child Support Enforcement. It's really hard to top Goddess, Nancy, there in the state of Washington. But
I thought you'd like that.
I do. I'm so pleased. And I'm really thrilled to have Gina and Nancy on today, because one of the goals for today's call, while we're going to give you an overview of the resource that we introduced during Domestic Violence Awareness Month, we also are going to just open up the webinar for people to chat in questions. We had a lot of questions chat in when we first introduced this resource back in October, and we weren't able to fully answer all those questions, and so we are going to start to address those questions today, but also then open it up really for you all, kind of like any question that you have about child support and why things work certain ways. We will do our best to answer those questions. And also a big thanks to our colleagues at the Family Youth Services Bureau. And I think, Rachel, you're on the call too.
Yes, thank you, Michael. My name is Rachel Orsinger. I'm a senior family violence program specialist with the FIPSA office, that's the Family Violence Prevention and Services Act office in FISB, the Family Youth Services Bureau. And we are just so excited to have this collaboration with the National Council of Juvenile and Family Court Judges and with the Office of Child Support Enforcement, and Michael in particular, to really delve into these issues and make sure that survivors and their kids are getting the support they need out there. So thanks, Michael.
Great. And so what I'm going to do, I guess maybe Linnell, if you want to give a little of the background on it, and then I'll kind of do the quick run through the booklet itself.
Okay. So our resource, Getting Child Support When You're Afraid of the Other Parent, is our home card or booklet, depending on how you look at it. As a result, obviously, of the collaboration between agencies, as we discussed, OCSE, FISB, and the National Council. We were working on and focused on the idea of creating an informational resource for victims around the child support process and common issues or questions regarding that process and that we thought might be of assistance to families affected by domestic violence. So we wanted to both answer questions that those in the field have seen or are understood as common, but also at the same time provide a general enough resource that it could be used across systems, meaning both all federal, state, and tribal. So we're looking to focus in on safety-based questions without providing any particular focus that would mean that it wasn't useful to somebody, say, in Oklahoma versus Texas. So we went with a safety-focused Q&A and checklist of questions for victims and for advocates working with victims when those victims or advocates are interacting with child support services or other agencies that might be linked with child support services.
Great. So I'll take us on a quick spin through the booklet, And, as Linnell said, we worked very carefully on this to try to make it so that it would work in any state and really do it as a series of questions so that for advocates and survivors, it would be the kinds of questions to ask of the child support program in your jurisdiction. So really wanted to start off with this, the idea in the booklet that it's a fairly common for parents to want and need child support, but then they can worry about safety and that, and emphasizing that parents in that situation are not alone, and also to note that there may be parents who do not want child support because of those concerns. And so one of the things the booklet includes is a question or questions to ask about how to not have to participate in the child support process. And so this section here has questions about what in most states is called the good cause exemption from child support participation when parents are receiving public assistance. In all states, that includes cash assistance, or TANF. In some states, that may include SNAP, child care, and Medicaid assistance. So that's what we covered in this beginning section. We then included just a basic definition of what domestic violence is to expand kind of the lens to which people think about domestic violence, and emphasizing that abusers may use resources and threats about child support and child custody, and linking that to survivor safety. A reminder for survivors to share if they have a protection order, to share it every time they visit a public agency. We've heard quite a common experience maybe that a survivor shares that protective order with one public agency, but then doesn't share it with others, kind of thinking that, well, I gave it to, I showed it to this agency, so everybody knows that that I have it. And that as much as we like to think that public agencies communicate with each other, the reality is that is not very common, and so I wanted to emphasize that part of that. And then what we do is, when it comes to talking about the child support, is we kind of walk parents through the kinds of things that may happen at different steps in the process. And so here, while we note that every state's different, there are some common steps in the process that we are highlighting with the booklet. So what happens when a child support case gets opened, and when does the other parent receive notice about that? And so some questions for a survivor to ask the child support workers about when the other parent will be contacted and how will they be contacted, and then talking about flagging their case for family violence, and then if paternity needs to be established, is there going to be genetic testing, and how can that be done safely, and address confidentiality, and how to have that flagged in their system. And one of the things, and we can talk about this a little bit more when we get to the Q&A section, but every state and tribal child support agency has a process for flagging a case. Many states will call it the family violence indicator. Some states call it address confidentiality. Some states call it participant protection. So the terminology may be a little different, but the impact of that marking a case on the child support system is that it suppresses address sharing across state lines, essentially. Some states have in-office meetings where they ask parents to come into the office, and so that we include questions about alerting survivors to that. And then we have questions about, and in some states, child support is very much a court-driven process, so that's not the case in every state. And so we include some questions about the court process and safety options for court. While most states don't address visitation in the child support order, 36 states do calculate child support based in part on, or the calculation of child support is affected by the number of overnights that a child or children is in each parent's home. And so child support staff oftentimes will ask about parenting time and the number of overnights. And so we include questions about that. There are a few states that do address visitation formally, but there's 36 states that address it in the child support guidelines and how child support is calculated, the amount of child support. And then we have some questions about after there's an order in place, how will child support be collected, and what happens if the other parent refuses to pay, and alerting victims to the fact that when certain collection actions might be taken, and they should be thinking about safety planning around those times. And then also a little bit of why a child support worker would ask questions about domestic violence. So just to reinforce that, when a child support worker is asking about domestic violence, it isn't just being nosy, or that there is some context for why a child support worker would ask those questions, that there are some things that child support workers can do to help make getting child support safer, and also to recognize that we work with community partners, and in many states that more and more child support offices are working with their local domestic violence programs. And so then a final link to the National Domestic Violence Hotline and the Strong Hearts Native Helpline if there are questions about child support and safety immediately, so they can get those answers. So that's the fast and furious version of the Palm Card. If people have questions specific to the Palm Card, I want to encourage you to chat those in. But what we're going to do now is go to some of the questions that were chatted in when we had our first call in which we introduced this. And I'm going to do a very brief kind of federal perspective on each one of these questions, and then I'm going to pass it off to our other two domestic violence and child support experts from states. From the state of Oklahoma, we've got Gina, and from the state of Washington, we've got Nancy, and we'll talk about how it kind of works in those states, recognizing that that's not every state, but it'll give you just a little bit of that flavor. And also, we may do some brainstorming on questions where there's not maybe a totally clear answer. At any time, if you've got a burning question about how child support works, something that you don't understand, something that you've heard maybe from a survivor that you're working with and doesn't kind of make sense to you, feel free to chat those questions into the chat box, and we'll try to address them as we go through the webinar. All right, so the first question that came in when we were introducing the Palm Card was if a victim of domestic violence applies for child support from their abuser, do they have to release their location if they're in a shelter? And so this gets to the address confidentiality or the family violence protection flagging that I mentioned. So every state and tribal child support program is required to have a process by which they will kind of essentially seal the address, block its release, when the state or tribal child support program has reason to believe that the release of that address could lead to the physical or emotional harm of the parent or children. And so the short answer is no, they don't have to release their location if they're in a shelter, or even if they're not in the shelter, if the release of that address information could, and it doesn't have to be proof that it will lead to harm. It's just that there's reason to believe it may lead to harm, and the state or tribal child support program can suppress any release of information from the child support system. Now, the one caveat I'll add here is that in some states, while the child support program can do that address suppression or address confidentiality, it'll be important for victims, survivors, to also ask the child support workers if that applies to the court, if it's a court-based system, and the court's release of that information, or the court putting that information on publicly accessible court document websites. So I'll pause and turn it over to Nancy and Gina to see what other things they'd like to add to this.
Now we're both being polite and we don't want to go first, but I will. This
Thanks,
is Nancy from Washington, and there's a whole bunch of answers I could give to this. One is, do I have to have a case? And if you apply for TANF, like Michael was saying earlier, you automatically get a child support case. But if you can claim good cause not to cooperate with child support, then we will not work the case. And any information on the custodial parent and the children's location is confidential and disclosed only under according to our statutes and rules. So if it's a welfare application and the person notifies at the time of application, I have domestic violence issues, then the referral is going to come over. The welfare computer talks to the child support computer overnight, and we have a referral. If there is no claim for good cause, then we just go ahead with processing the open case. If the case does show that there was a good cause request, then we wait and see what happens on the welfare side. I know that federal law says the 4D agency, the child support agency, is the one who should determine good cause, but long ago, I've worked for the agency for 30 years, and before I even worked here, the child support people said, we're not social workers, we don't know how to do this, so we have had an agreement that our welfare side makes decisions about good cause. And one reason this is important, especially if you have a good computer system in your state, is once we get a referral that comes from the welfare side, if there is not an indication that there's good cause, we have these letters. I'm sure they have a different name, but I call them welcome to the registry letters. And it, you know, dear mom, dear dad, your case, you've now got an open case with the Washington State Support Registry. And if you didn't want the other parent to know that there's a child support case, surprise, there it is. But if it comes with a good cause indicator, it's not, those letters won't go out. So Michael mentioned address confidentiality. We have a program in Washington State. I'm not aware that it's in every state, but I know other states have it, where through our Secretary of State office, you can, if you're a survivor of domestic violence or stalking and certain law enforcement people, you can sign up with this program, and they give you an official address that you can use for government purposes. And that way, everybody's address is here in Olympia, which is the capital of Washington. You have essentially a private mailbox. Mail goes to that mailbox. The Secretary of State's office sends it to you. The fact that you are in the address confidentiality program means we're going to deny a request for your address, because we have a process, notice and hearing on when we get a request for address, but we also have a provision that says if I look at your file and it looks to me like it would be dangerous to release your address, I can just deny it right then. And so we've got a multitude of stuff. And there's nothing that says if you're a survivor of domestic violence, you can't ask for child support. It's just, like Michael said, there's safety planning involved in what's going to happen. You know, talk to your welfare office, talk to your child support program.
Thanks, Nancy. Gina, anything you want to add on address protection and address confidentiality on child support?
Oklahoma works quite similar to Washington, it sounds like to me. We do have an address of record, so individuals can provide the address of record, and that is the address that we will release. We have a process to go through to get that release. We notify the individual that their address has been requested. So we do have that process. We do prefer that if someone is experiencing domestic violence, you know, obviously that their address of record be maybe a family member or a friend. It can be a P.O. box, something other than their finding location. Oklahoma also has the address confidentiality program. It's run through our Attorney General's office. So we kind of work very similarly in the fact that we are very protective of releasing addresses, and especially if someone is in a shelter setting, we do not want to release that information.
And if
Great,
I could
thanks.
just add, sorry, regarding shelters, almost every domestic violence shelter that I'm aware of is a confidential location. And one thing that means is I can't find out the location of a shelter, except I volunteer with our local DV program, so I know where the confidential shelter is in Olympia. We don't serve process on anyone who is in a shelter. There are other things like we don't serve you if you're in rehab or something. But like Gina said, there are ways to protect your address.
Correct. And if your DV program and shelter in your state is like ours, because I volunteer at our local one as well, even if the police show up and request information on a participant that they think might be staying in shelter, that shelter cannot either confirm or deny that that individual is in shelter. So it's very protective.
All right, so we had multiple questions about undocumented parents. Does the NCP have to live in the U.S. or can they be living in another country? Does the child have to be documented? What's required to file? And so I'll give kind of a high-level response to that, and then I'll go to Gina. I'll ask you to go first. So, so to receive child support services, there's no requirement that either parent be documented. People have said, oh, well, if I'm undocumented and I apply for child support, are you going to notify immigration that I'm undocumented? And child support will not do that. That's not to say that another person might not do that reporting, or that a batterer might threaten if the parent applies for child support that they'll release that information. But child support will not do that, and it's not required for services. The non-custodial parent, and I realize I put NCP in there, and I think that was the question, but NCP stands for non-custodial parent, or the parent who does not have custody of the child, and they do not have to live in the United States. Many countries are part of what's called the Hague Convention, so that's a cooperation convention that a number of nations have signed on to and agreed to honor each other's child support agreements. Also, many states in the United States have reciprocal agreements with states in Mexico to be able to pursue child support if a parent lives there. The child does not have to be documented. As far as what's required to file, really kind of just basic information about the parent. It may just be as basic as, their name, where they used to live or lived at one point, where they've worked. You don't have to know their social security number, or if they're not using their social security number but somebody else's, you don't have to have that information. If you can describe the vehicle that they own, all those are things that child support you can use to locate when providing child support services if you don't have all the information about the other parent. Gina, what would you like to add to that?
That's the way it works in our state and here in Oklahoma. We provide services and work those cases. Just like you outlined, federal authority requires that we serve all applicants regardless of their immigration status. I want to say back like in November of 2007, we actually had a House bill passed to kind of provide some guidance on working with a new immigration bill and kind of outlining how we approach working these types of cases. So yeah, we go ahead just like you said, and we serve all applicants regardless of their immigration status.
Nancy, anything else to add there?
No, like you guys both said, we don't really care about the documented status. We don't ask anything about that. If the child is receiving TANF, I may look at the case and go, oh, I wonder why mom's not on TANF, and it's probably because mom is undocumented. But it doesn't matter what your documentation is. And I have seen both requests from the federal government and then proposed legislation in Washington that would require government agencies to report any undocumented people in their caseload. And the Department of Social and Health Services, which is our child support, welfare, and other agency, has very, very strongly opposed anything like that. Number one, because we don't even collect that factoid. And number two, we have case confidentiality. So we're not going to do it unless we are officially ordered to do it. So again, it's going to affect your receipt of public assistance, but at least in Washington, we have some state-funded programs where undocumented parents or undocumented persons can get assistance, but we don't really care in the child support program.
Great. So there was another one of the questions that came in on our last call was a request for a link to the citation about non-disclosure, family violence indicator, and a protection order. And so I have included, so if you go to the OCSE website and go to our policy page and look up Action Transmittal AT 98-27, that's the link to that, the actual documentation for anybody that needs that. And basically, that's the policy guidance that the Federal Office of Child Support Enforcement put out in 1998 about family violence indicator and the level of documentation needed to put a family violence indicator on. And that policy guidance included when the state has reason to believe, and in that policy document it says if there is a protection order, then the state has absolute reason to believe, and that is absolutely enough reason to provide that address confidentiality. Let's move on to the next one. Okay.
Could I just add something there, Michael? In Washington, sure. We're very relaxed about that. If you tell me you have a domestic violence indicator and you are afraid of the other party on your case, I'm going to set your family violence indicator. I don't need a protection order, although any documentation helps. And in our welfare program, many years ago, in order to claim good cause not to cooperate with child support, they used to require some kind of documentation. Now, I think for the last 10 years, the requirement is you have to take my word. I don't have any documents. I may have left home, and I was more interested in getting my kids out of home than the paperwork. And so the welfare office will accept a sworn statement that I believe there's danger. So we're not into documentation at all.
And that's, in the Palm card, that's one of the things that we emphasize there, because every state's different. It's important for advocates who are working with survivors to know kind of what level of documentation is required in your jurisdiction, or where parents are going to child support agencies for them to get both the family violence indicator, and then similarly, there's questions about getting good cause exemption with the welfare side when receiving TANF. So many states are moving towards, and in fact, OCSE has been encouraging states to accept even verbal disclosures as a reason to believe that their release of address information could lead to that physical harm or emotional harm to the parent or child. But every state's policy can be a little bit different there.
Michael,
so
Oklahoma follows that practice. We are very lax as well. We will take your word for it. We're also very lax in individuals coming in and maybe they put it on and they change their mind and remove it and then decide a month later to reinstitute that. We try to trust the victim and what's going on in their situation, and if they need to add it or take it off, we do that.
Great. So there was a question about child support needing some guidance on how to best deal with victims pursuing child support and being threatened to waive past due support to them. And so this is, while this is mostly maybe a child support issue, this is something for advocates here to reach out to the staff working in local child support agencies to find out how they deal with this. If a victim of domestic violence has child support due to them, maybe that hasn't been paid for a year or 2 years or 3 years, and what's the process if they want to forgive that back support? What's the process for doing that? If they don't want to forgive it, but they're feeling coerced by the other parent, are there ways that the state child support or the tribal child support agency could help them kind of manage that? So I know in at least one state that the state, if a victim, and then they do this through the court process, and if the victim says, I want to forgive this back child support, the state's attorney will meet separately with that victim and ask them if they really want to forgive it or if they're feeling coerced. And if they're feeling coerced, the state will offer to oppose the release of those arrears. So the parent who's owed the money might say to the court, and in front of the batterer, Judge, I want to give up. I'm happy to waive these arrears. He actually has been providing support. Whatever they want to say, and the state though can say, well, Judge, the state's a party to this case, and the state opposes the release of these arrears. But in that state, the attorneys only do that if the victim says, yes, I want you to do that. All right, so that's an important part of it, is to have that victim-centered approach and to trust them, because in some instances we recognize that it may truly be safer for the victim to waive those arrears and for the state to go along with that. I think, Gina, you talked about in Oklahoma, you have a kind of a different approach where you put those arrears on hold.
Yeah, essentially what we do is we will try to, instead of waiving them, because the word waiver, essentially once that's done in an order, they're gone. You cannot go back and get those. So we will try to reserve them. So essentially what that looks like is we're not addressing it today, but it still leaves the option for that custodial parent to come in at a later date, maybe go to district court and try to get those. And sometimes in our court hearings, that's kind of the best you can do. If that non-custodial parent will go along with it, and a lot of times just the fact that they're not having to be addressed that particular day, they don't ask a lot of questions about what reserve means, we can get away with it. So that's one way to not just wipe them off of the system, is to reserve them.
Nancy, anything you want to add from Washington on this?
Yeah, we, unlike most states, have a combination of administrative process and court process, and there are different things that can happen. If the survivor is the custodial parent, the one to whom support is owed, they can ask that we close their case, for instance, and not work it. Or they could ask to forgive arrears. And one of the things, like Gina pointed out, is we won't write them off at the request of the parent. We will, however, not enforce them. And we have even seen cases where the survivor can write us a letter and say, I want to forgive the arrears owed by the other parent. And if it's, especially if it's a court order for support, our courts don't care if you have a written notice. What they care is if you got a court order either terminating child support or writing off the support arrears. And this happens in a lot. It doesn't have to be a domestic violence situation, but one of the parents will say, I waived the support arrears, and then come back in a couple years and say, well, no, I want it. And if you relied on that, you may or may not get equitable relief. And, part of the defense is, you told me I didn't have to pay, so I didn't, and I didn't save up my money in case you changed your mind. And, the court may find equitable grounds to say you lost, but it's a crapshoot, really. So we will just say, okay, we won't enforce it. Especially, if it's a DV person, I think it would be dangerous for you to collect. And I've talked about this before, but if I threaten to kill you, if I have to pay child support, I don't really care if it's current support or arrears. It's money coming out of my check. And so I'm going to take action against you whoever I'm paying it to. And so that's why we have the possibility to stop enforcement.
Great. Okay, so we had, so I just want to say in the chat we had a question about different responses or approaches to these issues for young parents who are under 18. So I want to just acknowledge that question, Sarah, and we'll get to that, all right? Please keep chatting other questions in. Kind of the short answer there is that, especially in judicial states, most judicial states are going to require, if somebody is under the age of 18, and if they have not yet been legally emancipated, for them to have an adult representative with them, and so there are different approaches oftentimes for minors, for people who have not yet reached the age of majority. But we'll come back. We may be able to come back to that and dig in a little bit more to that as well. So we had several questions about hospital paternity establishment and domestic violence. Is it possible to alert a hospital not to bring in the birth certificate paperwork if a biological parent alerts them in advance that they don't want the other bio parent to be considered a legal, the legal father? Does the mother have to give permission for the father to sign? And so this is a really great question and a really complicated and sticky situation, because all hospitals who have birthing, who have deliveries in the hospitals are required to offer parents the opportunity to, of course, fill out the birth certificate information, but then also to complete what's called an acknowledgement or an affidavit, or some states call them paternity notices. They have different things for them, but it's a voluntary paternity establishment or legal establishment of fatherhood at the hospital. And the hospitals may have worked out ways where they maybe try to talk to the parents separately. They may try to avoid sharing that information with the biological father. But I've done some surveying of states, and at this point, it doesn't seem like there's a whole lot of systematic approach to safety options for survivors at the hospital. And so this is where, if you are working as a domestic violence advocate with a parent who is pregnant, so if you're working with a prenatal client, for them to be prepared when they go to the hospital, to know that that form is going to show up, but then to also know how. So let's say that they feel coerced into signing at the hospital. They also need to know about the rescission process, and every state has a process to rescind or take back that acknowledgement or that paternity declaration form. And so that can be a safety option for a survivor. Gina or Nancy, anything you want to add to that, or should we move on?
I got nothing to add.
I would just add that in Oklahoma, we have it in our statute, and it outlines the process for having your name added to a birth certificate. So in Oklahoma, you either have to be married, you have to sign that acknowledgement of paternity, or it will be put on there by a court order. So that kind of takes some of the pressures off. I guess maybe in some states you can just have your name added to the birth certificate. I believe years ago, before we had it added to our statute, you could kind of do the same thing here. And then again, if you get into that situation, like Michael was saying, the rescission process for the acknowledgement of paternity paperwork, let's say that an individual did go ahead and sign that acknowledgement of paternity out of maybe duress or fear because that individual is at the hospital with them. In Oklahoma, they have 60 days to sign that rescission and take it back. So they've got some wiggle room there after the fact. But I do think that our statute and how a name is added to the birth certificate kind of prevents some of the fear-based, adding that name to the certificate.
And for the advocates on the call, the 60-day time period is a federal requirement, so that's going to be that 60-day period to do the rescission of that voluntary document at the hospital or after. That's going to apply in every state, that 60-day window to rescind the paternity establishment document. So what happens to child support when a victim relocates to another state? Gina, why don't you just take that question?
Okay. In Oklahoma, we'll just keep enforcing their case here, just like they were here. And I was kind of, thinking about this as I was reviewing the questions. And, I mean, you can ask that your case be open in the state that you move to if you choose to do so, but it might be better just to leave it in that original state. That way that non-custodial parent doesn't receive any kind of notification from another state to indicate, that they have relocated. But in Oklahoma, we'll just keep enforcing that case.
Nancy, anything you want to add to that?
Only the fact that it depends on who's going where. Do we have to refer to another state? And under the Uniform Interstate Family Support Act, we may need to provide the address to the other state, but there's also a process for a non-disclosure finding.
Okay, I'm going to go to the next slide. So this was one of the questions that was chatted in. I have a domestic violence client who owes child support. Although she had the child living with her for 2 years, during that time she was being charged but unable to pay. So it sounds like she had the child living with her, but there was a child support order in which she was obligated to pay. Currently her child is an adult but cannot drive because of the past due child support. Is there anything which could help her? This is, I'm not sure in this situation why her child cannot drive because of the past due child support. It is possible that a driver's license might be suspended for the person who owed the child support, but the child should not have their driver's license suspended because of the past due child support. The other thing is if you've got a relationship or working on building a relationship with the child support agency there, it may be possible to go back into this case and for the victim parent to document the period of time in which the child was actually living with her. And in many states, the courts will give credit for that period of time the parent had the child living with them and can wipe out child support for that time frame. Not every state, but in many states that's a possibility. Any additions, Nancy or Gina?
Nope, I think you covered it.
Yep.
Okay. Is there any assistance for survivors to get child support enforced once the non-custodial parent refuses to pay? Is there any guidance an advocate can give? So every state has kind of a common set of enforcement tools for enforcing child support. So, and many of those are automatic and done by the computer system in those states. So one of the very first things that happens is there's a negative credit report that goes out. Most states are going to start sending letters to the parent, nastygrams, threatening letters of some sort. States can suspend driver's license, recreational license, professional license. States can intercept tax refunds. States can put liens or levies on any kind of property, so bank accounts, house, car, boat, any kind of real property. Of course, much of those enforcement actions depends upon having a non-custodial parent who has some kind of official financial profile, for lack of better words. So in other words, they are working and or have worked and are kind of on the radar in some way officially. And we know that some non-custodial parents live and work kind of in the gray areas of the economy. But even in those situations, more and more child support agencies are doing things like taking Facebook posts that show a parent who claims to not have any income, making Facebook posts in which they, are holding wads of cash or driving a new car or that kind of thing. And so In those situations, it's really good for the survivor to be an active kind of participant in sharing that information with the child support agency so they can use that to move ahead on cases. And in pretty much every state, the child support agency can take court action for contempt on cases. In many situations, states now have programs to help put unemployed non-custodial parents to work so that they can pay child support. And we'll use that as a tool also to collect child support.
I think one thing is there are some states that will notify the survivor when they're getting ready to take enforcement actions, and I've heard them called green light, yellow light, red light states. We don't do that in Washington, and essentially it's because we have just a huge caseload and we don't have the resources to devote to that, so we essentially we're going to work your case or we're not going to work your case. And we recently added a little tweak regarding medical support, which if we have time at the end, I will talk about.
Great.
In Oklahoma, we kind of work the same way. We encourage the yellow light, red light, green light approach. If you can, especially in paternity action, sending out those genetic test results or taking any kind of enforcement action. One of the things that we depend on pretty heavily too here in our state is those tax intercepts. They might be kind of off the grid for a while, but a lot of people will go and file for their tax refund and we'll get money that way. And then in Oklahoma, over the past several years, we've gotten the lottery and we have a lot of casinos, so we like to take lottery winnings. That's always the fun one. If we can take that money that someone wins to pay their child support.
So just one other thing I'll say here for the advocates on the line, while child support agencies officially should take the same kinds of actions on every case, there are some actions that are more work-intensive than others. And many child support caseworkers might have 800, 1,000, 1,500 cases that they're working. And it's human nature for the squeaky wheel to get the grease. And so if you don't have enough time to provide that more intensive enforcement action to cases that, let's say, haven't made payments for 90 days, you take those actions on the cases where that custodial party has been calling you and bugging you and asking for an update on the case. And so that's where being proactive can be helpful in the enforcement actions that are taken. Next question. If a parent is in a situation where they are homeless due to domestic violence, are they able to still apply for child support? And the short answer here is yes.
Here's my short answer. Yes.
Yes. Yes. Yeah. I mean, the only thing will be is if they're homeless, is there some way, some address that they can provide where they can receive notices, receive mail? That would be the only requirement. So a post office box, and I was recently in Wisconsin, and I heard from a lot of domestic violence advocates there that they, even after somebody's moved out of the shelter, they will often times still let them use the shelter or the program's address to receive mail, and we'll get word to them that they've got mail to pick up. So having some way of getting, receiving mail, having notice, some way of being contacted would be the only requirement.
And also, here in Washington, we have done our best to get away from issuing checks, and we will hope that you're going to pick either electronic funds transfer, EFT, into a bank account, but our preferred thing is a stored value card usually with a Visa logo on it. So a payment comes in on my case, it gets loaded to my stored value card. We call it the DCS card because we're the Division of Child Support. So no matter where you are, even if you're homeless, you've got this card that has money on it.
Right, and every state has one of those. So that is something
okay.
that is common. Yes, that is something that's common across all states. Every state will have a way of doing the stored value cards. So the next question is, do both parents pay child support when both parents have custody of the children? So this gets into how states determine how much child support is due. So we call those child support guidelines in our child support language. And in about not quite 40 states, they will take both parents' income into consideration. And as I mentioned earlier, they will also take the amount of time that a child is in each parent's household. So what happens in those situations, it might be that the parent who isn't the primary custodial parent doesn't pay very much child support, but you don't have both parents paying child support to each other, right? It'll balance them out, and the calculation. So they might calculate it. So if I'm making this much money and the child's with me 40% of the time, this is the amount I should be paying, and the amount that the other parent is making this much money and has the children 60% of the time, this is how much money they should be paying, and it gets calculated out. So it might be that, if I'm having the children quite a bit of the time, I may pay a much smaller amount, but you don't have the parents paying it back and forth to each other.
One thing that happens a lot, I guess, more frequently is parents who end up with a 50-50 child support, residential schedule for the children, and they're likely to say, well, we have the kid the same amount of time, so we shouldn't have to pay. Well, that sort of makes sense if both parents make the same amount of money, but if one parent makes more money, our courts in Washington will say, no, we calculate according to your income, and if one parent makes more, then they're going to pay.
Great. Thanks for adding that, Nancy. So this is a question that came specifically from Michigan. In Michigan, we deal with the issue of victims succumbing to full joint custody and then continually being abused throughout those cases, all because abusers threaten them over being hit with child support and back support. And so this is where the issue, Michigan is one of those rare states in which when parents are going through the child support process, the courts generally do address custody and visitation. And so parents need to be informed before they get into the child support process that that's going to come up. And where we recommend that the child support agency connect victims who are trying to get through the child support process with legal aid or other legal services providers who could help them with representation around custody so that they're less likely to be representing themselves when it comes to that custody issue, which is very difficult for survivors to kind of resist succumbing to the full joint custody thing. In many states, going through the child support process doesn't lead to a custody order, not in many, in most states, to a custody order and or visitation order. And while it doesn't lead to that, it doesn't mean that the battering parent can't go file on their own to try to get custody, and we know that that's a very common threat that batterers use. And so when you're working with a victim in the child support process, it's also critical to be connecting them to other legal services to address the custody and visitation side so that they are not as vulnerable to so they've got that addressed before the other parent gets to filing in, basically, right? It's a little bit of a race to the courthouse there, and we want the victim to have as much opportunity as possible to get a safe visitation and custody order.
And also remember, I mean, it's a sad fact that very often the perpetrators have more money than the survivor, and they may win in court because they can afford an attorney and the survivor can't. And many legal aid programs are overtaxed, and you may not even get a legal aid lawyer. So this is a situation where, oh my God, this is a problem and it needs help. But you just have to realize it is a real problem, and safety planning is so important for someone like that. And we would rely a lot on the advocate side more than the child support program.
Anything you want to add on that one, Gina?
No, like you both mentioned, it's a very common issue, and we know that threat increases, during this time of seeking child support. And we work very closely with our DV providers in the community. We will refer customers. We have a safe line, which is almost like the domestic violence hotline, but it's local. That way that advocate can get on the line and safety plan with that individual. We also have several family justice centers throughout the state where you can walk in, you speak with what's called a navigator. They will kind of walk you through the process, and if you need to speak to someone at legal aid, they have legal aid attorneys on site, and you can speak to them about your situation. Now, whether or not they'll be able to take your case on fully, they can talk to you about that, but we're real big into referring out at this stage to make sure that there's a safety plan and everything's being taken care of by an advocate at that point.
Thanks, Gina. All right, we have one more group of questions. Any specific guidance if mom has a child as a result of rape or sexual assault, name on birth certificate? So I know there are a growing number of states in which there's been specific legislation filed and passed that addresses rapists' parental rights, and it basically excludes them from parental rights by state law. But this is this is one of those things that you would have to know specifically based upon your state as far as names on birth certificates and parental rights. As far as the child support side of things is concerned, if that information is given to child support, then that shouldn't affect the child support order amount, and the child support agency should not calculate any parenting time. If it's a state that's got credit for parenting time, should not be calculating parenting time in those kinds of situations. I don't know, Nancy or Gina, you want to add anything on that?
Here in Washington, we recently adopted the most recent version of the Uniform Parentage Act, and it cleaned up prior legislation that we had. And there are two things to look at. If there were criminal charges and a pregnancy resulted in a child, then in the criminal action, they can terminate the rapist's parental rights. There's also, on the civil side, during either a parentage action or a divorce, there is a special fact-finding hearing that can be held if there's an allegation of rape or sexual assault resulting in the child. And the court has several options. Almost always the court can, it's like, declare this person the parent of the child and then turn around and terminate their parental rights. The court also has the option, usually in consultation with the survivor, of ordering that person to pay child support. So it's like this non-parental child support order, and you have no parental rights whatsoever, but you're still paying. Or the court can say, you're not the parent, you have no rights, and you're not going to pay support. And there's a special provision that the court can say, no state child support agency and no court can make this person pay support, either establish support or enforce support. And we made a special request, could you put something in there that they have to tell the child support agency when an order comes up like this? So there's a variety of things in this. If you are in an advocacy role, there was special federal funding available for states that adopted this civil procedure. because it's outside the criminal realm and it's got a different burden of proof, but it can still happen that they can be termed not a parent.
That's definitely one to know, to ask at with your state child support or tribal child support agency about that.
I would say in Oklahoma, a large percentage of those cases, we usually see the good cause exemption claimed, and we don't pursue those typically. I would say probably the largest majority of those, that's what you will see happen, is it is a good cause exemption.
Okay. Next question.
And maybe, sorry, just to add a little bit, I've seen cases where mom has a teenage daughter. Mom has either a husband or a boyfriend, and husband or boyfriend gets the daughter pregnant. And so that is some level of statutory rape. We call it rape of a child here in Washington. And so if now grandma and the daughter and the baby go on TANF, grandma as head of household would claim good cause, but then when teenage mom moves out of grandma's household, she can apply for TANF on her own, and it's up to her whether there's good cause, even though the child was conceived as a result of rape or sexual assault. So the good cause, at least in our state, follows the custodian of the child, doesn't follow the child all the time. So it depends.
All right. We've been focused on order establishment, but the problem often arises in these cases that the non-custodial parent does not want to pay and job hops to avoid wage withholding. Often our child support agency doesn't seek to enforce the order or does so only after arrearages are extremely high. If the victim makes a motion to enforce the child support order, she may be subject to retaliation. Great point. How can the 4D agency or child support agency take some of the onus off the victim in enforcement? Is there a minimum that must be paid to avoid jail? So again, this is going to be somewhat state by state as far as the minimum to be paid to avoid jail. But this is where, as an advocate, you can be, and you should have a relationship. This is where it's important to have that relationship built with your local child support agency, so you can follow up with your contact there to say, hey, this parent has never, hasn't gotten paid any child support for 3 months. Kind of what's the next step on this, and what next steps should be taken, and where the victim may need to be somewhat of an advocate for themselves, and when it comes to paying. Nancy and Gina, anything else you want to add here?
Yeah, in Washington, we have 2 levels of good cause. I think we're kind of rare among the states.
Yeah, let's not talk about good cause. Let's talk about enforcement here.
Yeah, but part of the good cause level B is I don't want to cooperate, but I want you to enforce child support. And what I've seen happen with a lot of cases is then the survivor can say, I am not helping them. This is the state doing it to you. And so then that does, the perpetrator can't blame the survivor because it's the state doing it. Sometimes that helps, sometimes that doesn't. And as to avoiding jail, your results may differ depending on what state you're in, and especially in Washington, what county you're in, and is there an ability to pay? You can't put me in jail just for not paying if I don't have any assets to pay. So that is definitely a state-specific thing.
I was just going to kind of say the same thing, essentially. Sometimes our caseworkers will have to play the bad guy and make it appear that the state is the one who's initiating this and pressing the issue, and that's just what we have to do in certain cases to make sure that that survivor is protected and kind of to take some of the heat off of the situation.
Great. And again, as advocates, if this is something that's happening kind of frequently in your jurisdiction, this would be a good topic of conversation if you reach out to the child support program to kind of explore with them kind of At what point do they take certain enforcement actions, or should the victim expect them to take certain enforcement actions, so you can help manage victims' expectations as well. Next question was, how does child support work if someone retires early from the workforce and is only drawing retirement assets for living? What about SSI? What about incarceration? Any resources for low-income, non-custodial parents? So there's several questions wrapped up there. Gina, why don't you start off answering, and then I may chime in, and then Nancy, I'll have you share in.
Sure. So in Oklahoma, we can use retirement assets as income to calculate child support. We do not collect on SSI or our incarcerated cases unless in those situations we know that those parties have some sort of outside income, such as royalties, or for instance, I had a gentleman years ago that was receiving SSI. He fell off of one of the oil sites here in our state and was injured as a child. So he was set to receive $2,000 a month for the rest of his life as compensation for his injury. So while he was receiving SSI, we could still go after the money that he was receiving for his injury and use that as his income. So sometimes you have to get a little creative in those situations, but typically low income like SSI and incarceration, we're not going to collect on. We're going to use their income at zero. We used to have a program where we had individuals in the local office working with our non-custodial parents to help them with resources and jobs and different things so that they could stay current on their cases. We had to get rid of that several years ago through some budget cuts, but we do look at their actual income and the total number of cases that non-custodial parent may have to quote-unquote right size and kind of get their child support down to where it's something that they can manage and pay and actually get some money coming in on. Maybe it's not what the true guidelines would be, but we're using their actual income and actually getting some income into that family. And then looking for ways that we can partner with people in the community and agencies in the community that it's their job to assist with low-income cases and kind of help with resources and connecting individuals to jobs. Especially we have a large percentage of case members that maybe have felonies. So, you know, we're always looking for ways to partner so that we can connect those individuals to jobs.
And the only thing I would add to that is that in many states, if it appears that somebody has retired early as a way of reducing their income and they come in and ask for a downward modification of child support, in many situations the court will not do a downward modification because they would view that as voluntary voluntary unemployment, right, that they could continue to be earning at the same level they were earning. And so oftentimes, you know, I remember from my days in the state where we had somebody who was a doctor and they retired, and so, well, my income has gone way down, and so my child support should go down, and the judge kind of laughed them out of the courtroom and said, no, you can go back to work as a doctor. We're not going to change your child support.
Right.
Nancy, anything else you want to add to that one?
Again, we will look at what are the assets available to the person. We're not going to force someone to unretire, but like Michael said, it's probably not going to fly for a change for a modification in your support. One of the things I'd like to look at is the resources for low-income non-custodial parents. We have a program here in Washington called Alternative Solutions, and if you have issues, certain barriers to paying, we have contacts all over the state, and you know, with various alcohol, drug treatment, education, you know, job, skill things, and so there are some programs like that. Unlike in Gina's state, we still have the funding for that, but it's, you know, we do what we can, and some federal benefits we can't collect, some we can. So it all depends on the facts of the case.
Right. Just so you all know, as advocates, there are probably about 20 to 25 states that the Child Support Agency has some kind of program for low-income non-custodial parents. It may not be statewide. It might be in some counties to help them with employment. It is not anywhere near universal, though, in the Child Support Program. So the next question, do child support agencies provide guidance on financial stability? Very few do. There may be a couple that are using a program called Your Money, Your Goals. OCSE did some training with that financial coaching curriculum, but most child support agencies aren't going to do guidance on financial stability. And then the final question that was chatted in our last call was, how do we help judges understand domestic violence and that it goes beyond physical abuse? And I would say one of the simplest ways is to reach out to the host of this webinar, the National Council of Juvenile and Family Court Judges. They have a really wonderful family violence section and provide training to judicial officers on domestic violence. And in fact, I got to kind of see this in action when they trained all of the child support judges in the state of Texas a number of years ago. Did a day-and-a-half training. Child support and child welfare judges focused on the intersection of domestic violence and parents in those two systems. We at OCSE have some sample bench cards from some states, but I would guide you to NCJ, FCJ.
Thanks, Michael. I was wondering when I saw that question if I was going to get that handoff.
Yes.
One of the goals and purposes of the National Council is to provide ensure justice for every family and every child in the courts. And one of the ways in which the Council seeks to do that is to provide training and technical assistance, and that includes directly to judges. We have every year multiple, what we call our EJS, which is the Enhancing Judicial Skills trainings in domestic violence that's focused solely on that, training directly to judges, by judges to teach them not only just you can have the basic level of what is domestic violence and what does it look like, and then there's advanced levels depending on judges who have completed their earlier levels. And that's just the direct to judge training that we try to provide. We also do technical assistance, which and through different grants and programs, and that's one of the things that supported this webinar series and our work with OCSE and through FSBM for these webinar series, which is to provide basic information to improve safety, to help those working with judges and with systems to understand the steps and programs that are available to them, and the possible referrals and interagency discussions that happen. We also have, of course, at the end, there will be some resource citations, including where to find this webinar, but we also house the Resource Center on Domestic Violence, Child Protection and Custody, which has resources available, both downloadable and requests for print copies to individuals, to advocates, to judges, all of which provide as much guidance as possible about the intersection between domestic violence and these other areas of system response.
Great, thanks, Lynell. So at this point, we hope folks will chat in more questions. If there are other questions about the child support program that you have, I'm going to flip it then back to Nancy and Gina. Maybe Gina, if you'll go first, to the question that was chatted in earlier that I briefly touched on about different responses or approaches to these issues for young parents. So I think specifically we're probably talking about children who are parents who aren't either legally emancipated, haven't reached the age of majority.
Sure. We pretty much do the same protections and approach those very similar as any other case. I mean, we are going to be working with their parent or guardian or what we call next friend to accomplish that, but we're still going to be putting address protections in place. We're still going to be looking at that case as a whole as to how to help that individual safely pursue child support and make sure that everyone is safe, still doing those same references out to resources in the community and connecting them where there's a need. So we don't take too much of a different approach if they're a minor. I mean, we're just kind of incorporating their parent and putting them into the fold.
And then in Washington, with minor children, minor parents, our concern is if they're not emancipated or anything, then they need a guardian ad litem for the process. And we don't have any guardian ad litem process in the administrative form. So if one of the parents is a minor, we will refer the case to our county prosecutors to bring an action. You don't get out of jail free just because you're under 18.
So the other thing I would just add for those advocates who are working with parents who are minors, that, and this is going to be very much dependent upon the state, but in at least some states, if, let's say if mom is 16 and opens a child support case or has a child support case opened for them, and if dad is 20, the child support staff may be required as mandatory reporters to report that. And so just that would be something for the parent to be aware of, that while child support's got to keep the case confidential, if they're, depending on that state's statutes of what would be considered assault of a minor or statutory rape or unlawful sexual contact, whatever it's called in that state, then that may be a requirement that the child support worker report that to the Department of Children's Services in that state. Not every state child support worker and not every state's child support workers are mandatory reporters. If that's something you would want to find out, so that you can provide good guidance to your participant. We had a question from Deb asking about if this webinar has been recorded and also the first part of the series, and the answer is yes, both were recorded. And Linnell, do you want to tell people how to find the recordings?
Yes, so I moved us forward here so you can, there's a resource page that you can find the actual booklet, which is of course the basis for our discussion, both on the Resource Center's webpage as well as OCSE. And yes, this second in our series has been recorded. The first one was recorded as well, and I'm going to go ahead into the chat and type in the address where you can find that. But the easy answer to that is our website is rcdvcpc.org, and there's a search button, there's a resource button. You can do searches of all of the resources available, but it will be showing up in the chat window shortly. I'll get that address in there.
Great. So we've got about 10 minutes left. Feel free to chat in questions. If we don't have additional questions, we'll wrap up a little bit early, but do stay on the webinar long enough to see the web address that Linnell's typing in there, so you can get the recording of this webinar and also of the previous webinar. And I will give a big thank you to the National Council of Juvenile and Family Court Judges, Linnell and Anna, for hosting today's webinar, and my colleague Rachel over at the Family Violence Prevention Services Program. Thanks for being a supporter on this. We've got a few other people that are typing, so we may have some questions coming in. And also a big thanks to Gina Tharp from the state of Oklahoma, Child Support, and to Nancy Copter from the state of Washington. And for the advocates on the line, it's maybe the last time you hear Nancy's voice talking about child support, because she keeps telling me she's got retirement on the near horizon. And so a big thank you, Nancy, for being on today.
Thank you. March 31st is my last day of work, and April Fool's Day is my official first day of retirement.
That's somehow seems timely. So thank you, everybody, and have a great day. We'll wrap up the webinar a little early.
Bye-bye.
I just wanted to say thank you as well to everyone and for all of you for joining in and making this such a wonderful discussion. The link to the first webinar should be appearing in the chat for everyone to see. And as well, my contact information, I'll put that in there before we close out. So if there's any further questions about resources available from the Council, feel free to reach out.
Thank you.
Thank you, everyone.